my name is Jim Sexton and I'm your 2015 AAR President. I'm here today with our Real Estate Department Commissioner, Judy Lowe, as well as our 2016 President, Ms. Paula Serven. Thank you, ladies, for joining me today.
And thank you for joining us.
You bet.
My pleasure.
So we're here today to talk about TRID and some of the TRID changes that took effect October 3rd and the impact on the real estate department. So what's happening at the real estate department? Are you getting calls that maybe shouldn't be your calls, or what's making your phone ring?
Yes, we are getting calls. They started coming actually before October 3rd because some believe that it went in effect before October 3rd. And I think that there's a little bit of a misunderstanding around the government agency that is responsible for putting in place the TRID guidelines. And it appears that some believe that it was the Arizona Department of Real Estate. And I want to say right here and now that that's not the case. Remember that in government, that whole layer of government, there's the federal, the feds as we call them, and they are the ones that have put in place the TRID guidelines. And they created those guidelines to apply to the entire United States, every state and every local jurisdiction in the United States. And of course, they really didn't ask for very much input and still aren't inviting very much input.
That's true.
So then we look at our state government, our state agencies, and we have the Department of Financial Institutions, which is here in the building on the second floor, and they oversee financial institutions, the lenders, the mortgage brokers. They also oversee escrow. They also very recently took on the appraisal segment of the loan process. So that's the Financial Institutions Agency. Then we have the Department of Insurance, which is also here in the building, and they oversee the title insurance. And then we come down to the ground floor of the building and we have the Department of Real Estate, and everybody knows that we license and oversee the real estate industry.
I see.
So when someone gives us a call and wants to know about TRID, we very quickly let them know that that's outside of our jurisdiction. There are certain items that we've addressed that we'll be talking about that are within our jurisdiction, but primarily the best place to go is to the Arizona Association of Realtors to get their answers.
I appreciate that. We do have an awful lot of resources that are there, and including a couple of videos that we've already done. Paula, did you have a question?
So, Commissioner Lowe, how is the department involved?
When we looked at the guidelines that TRID has employed, we looked at it from, there are lots of statutory items that are within that, fiduciary responsibility, no misrepresentation and all of that. But how do the new guidelines really apply to the real estate licensee from a government statutory position? And the only item that we could see that we really needed to talk about and clarify was the closing statement. So when we looked at it, Jim actually called and said, so what is going to be required in the broker's file that the broker must keep for 5 years after closing? And we tossed it back and forth. That we came up with a couple of decisions that really couldn't be implemented just the way that we had talked about them, which was the closing disclosure document. And initially we thought that would be the requirement and quickly found out that can't be the requirement. So then we brought a group together and worked with AAR to talk about what does the closing statement need to have in it to meet the statutory requirements of the Arizona law. And we looked first at what's required in the broker's transaction file. We went to 215101. That's the statute number. And let me read it. The records required by statute shall include copies of the earnest money receipts, confirming earnest money has been handled in accordance with the transaction, closing statements showing all receipts, all disbursements, and all adjustments, sales contracts, and if applicable, copies of the employment agreement. We know that different brokers keep different documents in the file and have different requirements, but those are the things that are required. So we saw closing statement. And then we went to rule and looked at, so what's the definition of closing? What does a closing, at what point or what does a closing look like from definition terms? And in rule, there is 28101, which says, closing means the final step of a real estate transaction, such as when the consideration is paid, all documents relating to the transaction are executed and recorded, or the deed is delivered or placed in escrow. So that very different from what CFPB is calling the consummation.
Right.
This is the closing according to Arizona state law. So the closing document that we needed to have designed or developed would have to have all of those items on it.
Very good. So there is specific law, so closing had to be defined and worked through, and came up with the fact that if there's not a HUD-1 available, then we're going to go with a document that I think everyone is calling a settlement statement, which we see frequently now, in fact, primarily now, or if this were in August, prior to the 10/3 start date, we would have seen it in cash transactions.
That's right. Remember that there won't be what's called a HUD-1 now coming up in all of the coming closings. But it's our understanding from all the meetings that we've had with you and the partners in the transaction, there are pretty standard closing statement being developed. Might have a few proprietary aspects from what the individual title escrow companies are requiring, but all of them that we've seen are relatively standard. They look very similar to the HUD-1. They don't say HUD-1 across the top. And the only thing that we're encouraging is that it says all receipts, all reconciliations, and all disbursements. And that means everything that was paid out of that escrow. I don't know that past closing statements have been that specific, but when we reviewed what the closing statement must have, that was all. It's not underlined in statute, but in our brains it should be underlined.
Well, and I think that's something that we're still working on, because some title companies have said, I'm going to give the buy side their closing statement, I'll give the listing side the seller side. But the question is, and it sounds like what we're looking for, is to have the combination one that be part of the file.
That's right, and fully executed is the other thing. You know, some title companies brought to us that they don't send out the fully executed closing statement to the broker. Sorry, state law says that that's what's required in the file.
Which we did have conversation on as well. And the one that gets signed is typically a pre-closing. And then when you do get the final closing, it's going to be stamped and certified. And is that going to work for the final?
That'll be the final.
Okay, so.
And that should go out to the broker. And what a great service for a title escrow company to maybe just scan it in and send it right over there to the broker. The certified, it doesn't say certified in statute, so it doesn't have to be certified, but I would guess that the broker would want it certified.
Sure, great. Well, some of the other changes that TRID has introduced to us are things like broker license number or agent license number, which is included in the purchase contract, hopefully, if it gets filled out properly.
That was one of the nice things in looking at the disclosure, the closing disclosure document that TRID was distributing, the one that will only go to the borrower now that we know about it. And in looking at that, it does have very clearly the name of both brokerages, the name of both of the listing side and the selling side of the licensees, along with their license number.
Sure.
So how will title and mortgage get the license numbers from the department?
We're hoping that they'll come to azre.gov, just click on online services. They can come with the broker number, the sales agent number, or the last name of the individual. And it will automatically search for that. It will give them all of the information regarding that individual, including the expiration date of their license. Because we like to remind everyone involved that it is against the Arizona license law to pay an unlicensed individual.
Yes.
And that even means after their license has expired, unless there is authorization to escrow from the broker to pay, to disperse it if an individual licensee has left their company or left the
Let's
business.
follow up with that and talk about other tips that we might be that the department is concerned about, because I know that you've been to Arello and national meetings and other meetings throughout the state, and you've heard a bunch of feedback. What about payments outside of escrow or things outside of escrow? Where's the department on topics like that?
Well, you know, Jim, I serve on the board of directors for Arello, which are the licensed law officials of America, so to speak. Actually, we're international now. And a common concern is the payment outside of escrow. You know, when that closing disclosure document is sent to the borrower 3 days before escrow closes, and it has changes, and it's sent back to the lender to be modified and then sent back. You might have to establish a new closing date. This can happen a couple of times, and it will be so easy for those licensees involved in the transaction, or the buyer or the seller or somebody that is desperate to have the closing, I call it the miracle of the closing, occur, that they'll say, let's just take care of that outside of escrow. Don't do it. Whatever you do, don't do it. Because everyone who knows about that happening will be held responsible for that violation.
The lender, well,
lender?
we'll start from you. We'll start first the department. The department wants to see the settlement statement 100% accurate.
Accurate.
That's state law. We have now federal law, CFPB, that wants to see the settlement statement, the closing disclosure, to be accurate and not have workarounds, if you will. So I couldn't agree more. In fact, you know, we talked about things that are being done outside of escrow, but and we still hear on occasion about cash back to buyer.
And we all know that there never can be cash back to buyer.
Right.
That dates back to the time when you and I first got in the business, and that was a long time ago.
Different market, a lot different regulations back then.
Oh, yeah.
Right?
Oh, yeah.
Great. Well, anything else that you'd like to share with us about TRID and some of the changes that are coming up?
No, except that I think it's a great opportunity for the real estate licensee to stay involved and to bring their invaluable value to the table and know every piece of the transaction.
Great, and I know that there's a number of resources that are available, you know, at the federal level, and why don't you share with us what this one's about?
Well, I did visit with CFPB in Washington, D.C. 3 weeks ago, and they had just posted the Your Home Loan Toolkit. Mm-hmm. And it's in English and in Spanish, 25 pages, and they're suggesting that that be delivered to the borrower at the very first opportunity, preferably by the real estate licensee.
So thank you so much for spending some time with us and telling us about the CFPB from the Department of Real Estate's perspective. We certainly do appreciate it. So again, thank you, Commissioner.
Thank you, Jim, and thank you, Paula, for coming to visit us here at ADRE.
Thanks for having us.